with 6+ people, at least 6 people, and the officer has no idea who they are. None. No idea. He said, I don't know anything about them. I wasn't focused on them. That seems to me to be insane. How can you not know who the other people are? Isn't that important to know that? Wouldn't you want to know? I mean, at the very least, they're being left alone with all this stolen material, right? All this stolen merchandise. So why wouldn't you find out who these people are? It doesn't make any sense. There's no reason not to do that. But the officer said, I wasn't focused on that. You guys saw how many police are involved in this. You can't spare an officer to, talk to these people and jot down their names, see what they look like, see if any of them look like Mr. Bernard, maybe, see if, are any of those guys 6'2", kind of light skinned, maybe got some facial hair? Anybody like that? Anybody that looks like Mr. Bernard? Except, with the problem solved, the state's problem. It's like Mr. Bernard's twin brother could have been in the house wearing Reeboks, with the rest of the stolen stuff, but no one would ever know. It's crazy. Wouldn't really matter because he still wouldn't be the right height as the person that did this. He still wouldn't look the same color, but still, that's the point. Is why don't they know this? Why can't they answer that question? They can't. They can't answer that question. You gotta have to ignore it or say it doesn't matter. You should find him guilty anyway because I say so. Because crime is bad and you should punish him or something. But that's ridiculous. That's not how the system works. Really, I think that Mr. Malik, the only thing I agree with is the issue of consciousness of guilt, right? I talked to Yankee, who, in between making up stories about the thing before, he said some things that were probably honest, which is they did this bumper-to-bumper method, right? Why is that important? If they're bumper-to-bumper, that doesn't prevent you from opening the door, right? Okafor runs away, consciousness of guilt. That makes sense. Why are you running from the police if you didn't do anything wrong? Making stuff up. They're not making stuff up about Mr. Okafor. If you look at that shoe print, great, it's not the greatest thing in the world, but it does seem to match. If you draw the line and do the same thing, it's going to match. I can tell by looking at it. You'll be able to tell the same thing. They don't need to make up anything against Mr. Okafor because they got Mr. Okafor. He did. He ran. Mr. Bernard, the evidence suggests that they missed something. That's what it suggests. Is there evidence against him? Sure, he had stolen stuff. I understand that. But that's not enough. It's like we talked about, we talked about this on Monday, I think, or maybe on Tuesday. We talked about cases where the jurors get it wrong and you find out afterwards that they got it wrong. And everybody said, everyone agrees that that's bad. And that shouldn't happen. But there's only one way to keep that from happening. And it's from looking around at the evidence and testing the state and saying, have they really done what they need to do? I understand the momentum is pulling me. It's like being that Gator fan. You're convinced your team's going to win, despite evidence to the contrary, despite the fact that your kicker stinks and your offensive coordinator is terrible. But if you want them to win, they're pulling you in that you want them to win, but when they don't do it, you just got to say, you know what, you didn't do it. You don't have the evidence. I'm not willing to make that mistake for you. I'm not willing to make up for your officers who can't document who else was in the house, who can't figure out why one witness doesn't give a percentage and everyone else does. Why are you saying it's 60%? What's the problem here? You know, if you stared at his face from 6 feet, how come you're not sure? That they don't bother to say that the gun is actually facing like the driver put it in there. Your job is to call them out on that and say, no, this is not sufficient. You haven't convinced me. I'm not going to advocate my responsibility because it's easy. I'm willing to go home and say, I don't care what anybody says to me. I did the right thing. It was my responsibility. I told them I was going to do the right thing, and I did the right thing. You got to say, show me, state, show me the evidence, and when they don't show it to you, you got to say, tough luck. I don't care that we're on TV, and I don't care that we're in this big giant courtroom. You haven't convinced me. You haven't proven it. I'm not going to take somebody's liberty away from them with these amount of questions. Every single time you have a question, look over at that table and say, answer the freaking question. And they can't do it. Mr. Bernard is not guilty because they failed. And it's your job to say, you failed. I'm not satisfied. Find Mr. Bernard not guilty.
Thank you, Mr. Clark. Adrian, do we know whether the lunch is here yet? Okay, thank you. Let me see counsel for just a minute. Folks, you can stretch your legs if you want for just a moment. All right, folks, I was just checking with the deputy. Your lunch is not here yet. It's probably stuck in the elevators coming up, but it's on its way. It was ordered a while ago. I'm afraid that if we start with Mr. Malik's rebuttal in this matter, your lunch is going to come right in the middle of it. So what we're going to do is go ahead and send you back to the jury room. Your lunch should be here in just a few minutes. It'll give you a chance to use the restrooms and get ready. When you come back in, when you're done with lunch, when you come back in, we are going to have Mr. Malik's rebuttal. Then I simply need to go over the verdict forms with you, and then the case will be yours. So there's not a lot left once we finish the rebuttal. You're in a difficult position right now because you have heard all the testimony. You've seen a lot of the evidence. You'll see more of it when you take it back in the jury room. You've heard the initial closing argument of the state. You've heard the closing of the two defendants, but you've not heard the rebuttal. You've heard some of the law, most of the law, but not all of it, but you haven't even had a chance to see the verdict forms. Your inclination is, I want to decide this case, I want to get moving, but I need you to keep an open mind still, if you would, until Mr. Malik finishes and I finish with these verdict forms with you. Which means, while you're back there eating lunch, do not discuss this case. You've got your cell phones, you've got your computers. Please, 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 you've been so good so far. Do not do any research about it. Don't look up any news, local news, or anything else on the matter, and don't do any research on the issues. What I'm going to do is tell the deputies that we'll plan on about 30 minutes from now. If your lunch gets here pretty quickly, that should work out. If your lunch is delayed a little bit, then we'll stretch that time for you. We're going to check with you within 30 minutes to see whether you're done. If you need more time, that's fine. Okay? Thank you, folks. Leave your pads here, if you would, please. Leave your jury instructions here. Please be seated. Mr. Malik, I forwarded you an email, copied everybody this morning. When I was reading the jury verdict forms, there was an issue with regard to the robbery. You have defined in the jury instructions deadly weapon, but there's not a finding on there's a finding regarding firearm, and there's a finding regarding a weapon. There doesn't seem to be one on deadly weapon. You might want to take a look at that at the lunch hour and get with Mr. Davis and Mr. Clark if we need to modify that before I go over the jury instruction, the verdict forms with them.
And Judge, I think that was just the only lessers that.
I'm sorry?
I think those were the only lessers they were requesting. I don't think they requested the. I mean, we can add it if they wanted.
The problem is in one of the instructions. You'll see. I'll go over it with you in a minute. Is there any other matters that we need to do on the record, Mr. Malik?
No, Your Honor.
Mr. Davis?
No, sir, Your Honor.
Mr. Clark? All right. It's a quarter of. Let's plan on a quarter after 1. If the jury is done, we'll start up. If they're not done, we'll give them a few extra minutes. I'll understand that if you're eating lunch and are a few minutes late, we're not going to hold you to that. So we'll be in recess. Jury instruction.
Yeah. Oh.
Jury instruction on this robbery. It talks about define just firearm.
Right.
This one talks about deadly weapon. Then you should find him guilty of robbery with a deadly weapon. That finding is not in here.
Right.
So.
And I think the only reason did it because those were only the. Sorry. These are instructions, and those were the only lesser.